The last panel aims to reflect on the Nuremberg Forum discussion so far, on its objectives, on its attempt to situate the Nuremberg Principles within the framework and system, or system seeking accountability, to dissect various challenges highlighted throughout the past 2 days. Objective of the panel is to review the various discussions on the legal framework, answering the main question for the event, and from the perspective of the experts. Has the fight against impunity been living up to the Nuremberg Principles? What practices support your conclusions, and what suggestions strengthen your conclusions? We have discussed over the past 2 days the issue of universal jurisdiction, more visible approach in terms of accountability by using universal jurisdiction, and explored the scope of universal jurisdiction. Experts have highlighted already some challenges connected with domestic capabilities, and with panel 7, we hope to bring on more practical examples of universal jurisdictions and challenges connected towards them. We have also talked about peace through justice debates that has been covered in terms of raising complexities behind the objectives and potential need to prioritize some objectives over the others. The question that we are posing to these panels is related to what other developments does the field itself bring in this regard. We have also had reflections on highlights from day 1, and we have covered today additional challenges and highlights, including various efforts in achieving accountability. We have talked about establishing tribunals, establishing new investigative mechanisms, drafting conventions towards addressing some of the legal gaps and seeking domestic prosecution. And we talked about ongoing efforts in seeking accountability to strengthen justice and access to justice. This panel doesn't have it very easy, as we are really aiming for more practical and tailored conclusions to the question. But we do have an excellent group of experts today around the table. And I will do brief introductions before I hand over to our chair, Mark Ellis. Dr. Mark Ellis is the director of the International Bar Association, and leads the world's foremost organization of lawyers. He has served as legal advisor to the Independent International Commission on Kosovo and was appointed by the Organization for Security and Cooperation in Europe to advise on the creation of Serbia's War Crimes Tribunal. He was actively involved with the Iraqi High Tribunal, and he was appointed chair of the United Nations, created advisory panel on matters relating to Defense Council of the mechanisms for international criminal tribunals. We have with us today also Dr. Anna Neistat, the legal director of the Docket Initiative at the Clooney Foundation for Justice. Clooney Foundation for Justice is a leading foundation that promotes work on pursuing accountability for perpetrators and enablers of international crimes and support survivors in their pursuit of justice. Dr. Neistat has been involved in international human rights work for more than 2 decades and has conducted over 60 investigations in conflict areas around the world. Before joining the Clooney Foundation for Justice, she was Amnesty International Senior Director for Research and Associate Director for Program and Emergency at Human Rights Watch. She is currently chair of the board at Crisis Action and an honorary professor La Universidad Autónoma del Estado de Hidalgo. We also have with us today Ms. Akila Radhakrishnan, and I apologize for probably very mispronouncing the names, who is the president of the Global Justice Center. Akila directs Global Justice Center strategies and efforts to establish legal precedents, protecting human rights and ensuring gender equality. She has authored numerous shadow reports, legal briefs, and advocacy documents, and provided legal expertise to domestic and international stakeholders, policymakers, including the ICC, United Nations, and the EU. Prior to the Global Justice Center, she has also worked at the International Criminal Tribunal for the former Yugoslavia. It is our great honor to welcome you all here, and thank you for joining us for the last panel And we look forward to your intervention and conclusions. Thank you. And Mark, chair is yours.
Jelena, thanks very much. Welcome, everyone. It's wonderful to be here, and what a great conference this has been. So we hope we can add to it and match the impressive discussions and presentations that have come before us. So let me just say a couple words and try to bring in some of the points of the first day. And we've continue to talk about Nuremberg and the fact that that was really it represented a shift whereby protecting the sovereignty of state became really secondary to protecting the human rights afforded to individuals. And this is what we're going to talk about today. But in essence, states in principle would then be held accountable for violating the rights of their own citizens. And we see this in the Nuremberg Principles themselves, and particularly the one that refers to any person who commits an act which constitutes a crime under international law is responsible, therefore, and liable to punishment. So when we talk about Nuremberg, we talk about really the cascade of accountability mechanisms that emerged in hope that they would lead to a situation where we no longer have immunity for these gross violations of international law. And as the Cold War ended, 1989 really brought what is referred to as the golden age of international justice. So we'll talk a bit today about the kind of the collaboration that existed in that post period of time, the accountability mechanisms that proliferated, and this was exceedingly important for the international community. But one of the things we need to address today is this golden age of international justice. Is it waning in any way? It certainly is facing significant challenges. And I think I and others are concerned that there may be an apathy towards justice and accountability. And this is what we need to try to reverse. And let's remember that this impunity trend continues, even though we'll talk about some of the positive aspects today. But the number of civilians killed in conflict between 2016 and 2020 was 2.5 times higher than the previous 5-year period. So I think this should give us a moment of pause as we look at what are some of the practical steps that we can embrace in order to continue to strengthen this issue of accountability and to counter impunity. So today we have, all three of us will talk a bit more detailed about this. I'm going to ask some questions to our panelists, and then I will invite others that are listening later on to put your questions in the chat box, and we'll get to those as well. Akile, I'm going to return to you first, because you've done some remarkable work in this area, and particularly in this issue of peace and justice. And the question I want to ask you is there a switch from the peace through justice principle that we're all aware of towards really a peace through human rights? Is it an expanded narrative that we're facing right now? How do you address that?
Great. Thank you so much, Mark. And thank you so much to all the organizers for including me in this important event. I've been following it over the last 2 days, and the conversations have just been so wonderful and rich. And so really reflecting on the conversations, I think, that's really the starting point for my answer. It's so clear from the last 2 days that when we talk about justice, the notion of justice, what it means, who and what is encompassed by it, they're really quite broad, and they've evolved significantly since the adoption of the Nuremberg Principles. So the post-World War II period has been marked by the dual developments of, this concept of international justice for mass atrocity crimes, as well as the development of the actual modern framework of human rights law, which itself is rooted in concepts of justice and equity. And, this duality, for example, is reflected in the UN Charter, which sets out as the purposes of the institution both the need to maintain international peace and security including, as they say, in conformity with the principles of justice, as well as the imperative to promote and encourage respect for human rights. And similarly, as the previous panel discussed, the dual concepts are also embedded, for example, in the Sustainable Development Goals, particularly in Goal 16, as was discussed. And so, in my perspective, concepts of justice and human rights, they run in parallel with each other, and perhaps more importantly, they're intertwined and mutually reinforcing. And I'll address this idea in two different ways. First, in looking at the connection between human rights and situations of mass atrocities, and second, in looking at addressing what each of these brings to the table. So, to the first, situations that result in mass atrocities don't come out of nowhere. Rather, most of these situations are preceded by systematic human rights violations. And here we can look at Myanmar, a country that my organization has worked in for the past 15 years, a period which has been marked by military rule, a quasi-democratic transition, persistent internal armed conflict, genocide, and a likely fall back into military rule. And I'll zoom in here on the situation of the Rohingya, which was also discussed by Kingsley in the previous panel. So the Rohingya genocide was preceded by decades of discrimination and human rights violations, laws that deprive them of citizenship, restrictions on movement, and policies to control the size of the population are some of the examples. And these are policies that were perpetuated and tolerated by the so-called civilian government, and as well, and importantly, policies that were largely ignored by the international community in its pursuit to make Myanmar an international success story. And so the answer to the Rohingya genocide certainly lies in justice, which is currently in progress with an ICC investigation, a genocide case at the ICJ, as well as the work of the IIIM on Myanmar and potential universal jurisdiction cases. But justice alone cannot bring peace for the Rohingya. Peace for them is contingent on the restoration of their human rights and the dismantling of the system of discrimination against them. Otherwise, they remain in a perpetual state of vulnerability and marginalization and a continued risk for atrocities. And I think we can also look at this issue from a thematic perspective rather than that of a particular situation. And this, again, is the lens that my organization, which is focused on gender equality, really operates. Because gender and gender equality, a concept firmly rooted in human rights, is actually very strongly linked to stability and peace. And we have some good statistics and studies that look at this. So, for example, violence against women is a predictor of whether a society is generally more prone to violent conflict. The larger a gender gap, the more likely a country is to be involved in inter- and interstate conflict and use violence as a response in conflict settings. The higher the levels of violence against women, the more likely a country may be to not comply with international norms and treaty agreements, and the less peaceful it will operate in the international system. And finally, countries with low human rights standards, including low standards regarding gender equality, are more likely to have militarized and violent interstate disputes. And so, as these statistics indicate, the pursuit of gender equality as a human right can be essential to the achievement of sustainable peace. And more broadly, this demonstrates the importance of the peace through human rights frame. And, second, kind of looking at this from a slightly different perspective, the pursuit of human rights and justice often target different actors and address different parts of the puzzle. So while international criminal law is largely focused on holding individuals to account for their actions, human rights is a framework for holding the systems that enable atrocities to occur to account, including states. But as we're seeing and has been discussed over the last 2 days, with new developments, corporate actors, and multilateral institutions themselves. And so I think my answer is to achieve sustainable peace, we need both. And I'm happy to pick up on any of these concepts in further details in conversation. But, my answer to the question of the paradigm of which we're in peace through justice or peace through human rights is that we need both. They're interconnected, mutually reinforcing, and really we need both to address these kind of larger concepts that we're talking about.
Keely, let me ask you, because that's fascinating. And one of the things about you were saying that you could actually see this in an incremental kind of sequencing this a bit. So indicating that first you have this human rights kind of attack on the human rights, particularly this issue of violence against women, gender equality. So that's a human rights matrix. And then you describe the idea of mass atrocities, and you alluded to the fact that there are mechanisms that exist, as you say, the ICC, the ICJ, universal jurisdiction. But if you're suggesting that we need to keep our eye on those early stages of the human rights violations, particularly this issue of gender equality, because that will easily lead to the mass atrocities. What exact mechanisms do you see that can be used in the early stages in this human rights arena as it moves? What are those?
Sure. So, I mean, I think this is where you have the robustness of the both international and regional human rights systems. You have treaty body monitoring, you have monitoring and accountability from what the Human Rights Council does, OHCHR, they all do these mappings, these reporting on what's going on in particular countries. Civil society is deeply engaged in providing information on the situation of human rights in a country. And I think we often marginalize these processes and don't treat them as seriously as they need to. One of the many crises the multilateral system is facing is the financing of treaty bodies themselves and their ability to, which is impacting their ability to do their work in an expeditious manner, right? And I think there's so much that we can think about in this context. And you also have domestic litigation of human rights issues that you can do through national courts, you can do through individual complaints mechanisms. And so I think there's a range of of places where we can go. And, in places like Myanmar where we've worked with women's groups for over 15 years. And these are all different targets and, avenues that we've engaged with to raise a lot of these concerns around gender equality, to raise, the lack of a violence against women law in the country. That's something that has been brought to both CEDAW, it's been brought to the Universal Periodic Review. It was documented extensively by the fact-finding mission for Myanmar. And so there's a lot of these different places where I think you can start to engage with these concepts, and we need to be taking them seriously because justice is incredibly important in the aftermath, but our goal is prevention. And there's been a lot of conversation about what prevention looks like. And I think if we are able to address these systems that allow atrocities to happen in the first place, we're in a much better place than having to deal with these crises of what justice looks like in the aftermath of mass atrocities.
You represent, and your own background has shown the important role of civil society, and you've talked about treaty bodies, emphasizing the importance of treaty bodies providing the type of support they need. But I suspect you would also say civil society plays an exceedingly important role, I guess, in this early stage of focusing on potential human rights violations and providing resources in order to avoid those types of violations.
Certainly. Civil society often knows exactly what's needed on the ground. They are often the first ones to talk about years before any state actor is involved in a conversation about whether there's a threat of violence that's occurring. It's civil society that's on the ground, that's in the community, that's providing the resources, the services provision in the ground, who know the needs of the community, who know the threats of the community. And, there's a real lack sometimes of listening to those voices, validating those voices at the highest levels, tasked with those who are tasked with international peace and security. So in the context of Myanmar, again, I can go back to work we've done for decades with the UN Security Council, where you couldn't get attention to Myanmar before 2017 unless you wanted to say something good about them. But our civil society partners from ethnic groups were warning that conflict had not abated, that there were continued violations of their rights that were going on, that the peace process was stalled, that the country was in a very vulnerable place to fall back into military rule, which is exactly what we've seen. And I think that heeding these warnings, heeding the voices of those who know what's going on in their communities is so incredibly important.
So heeding this warning and the idea, and that's, I think for anybody listening here, one would say, well, that's a fairly disturbing insight to say, well, civil society has been speaking out on these issues time and time again in a very, very early stage, and nobody's listening. That has to be troubling. Is it just lessons learned, or are there actual things we can do to ensure that the international community, governments, government bodies listen more intently to the voices of civil society because they know what's going on earlier than most?
I think there's a lot that can be done. I think you can center, in the questions that are being asked, in what sets the agenda, the voices of civil society. I think, one thing, again, many different things we experience as a part of civil society, but one is, an international organization that works with grassroots partners. There's a lot of a sort of fetishization of civil society voices, right? We want to hear from survivors. We want to say that, we're listening to you. So you bring them to these venues, you bring them to brief the Security Council. But if you look at the actions, they're almost never responsive to what is actually being raised by civil society. And I think that disconnect is what really needs to be addressed here. Is it needs to be a more meaningful commitment than kind of this superficial understanding that you have to include civil society voices in the conversations that are ongoing at the highest levels. And this transition to say that civil society is being brought to the table to set the agenda, and that we're actually going to be guided as much by what civil society and those on the ground are calling for as we are by, the geopolitical conversations that are ongoing. Because, we're seeing more and more crises with politics getting in the way of any sort of resolution. And I think that's, that's one way to sort of break this paradigm is whose voices are centered and what types of solutions are prioritized.
Anya, as I sit there and listen to Achilles focus on this civil society part of it, looking at kind of this matrix of the players in it, states have a really important role on this as well. What are then some of the observed limitations of state responsibility in this fight against impunity? Achilles talking about the need for civil society, but how do we strengthen state responsibility in this field as well?
Thank you very much, Mark, and it's a pleasure to be here. And I think Achilles' wonderful remarks make me probably go straight into one of the things that I was going to say later on. But it made me think this last very, very important point about the fact that we live in the day and age where when atrocities happen, the world knows much more than it was the case even 10, let alone 15, 20 years ago. And for me, that, of course, increases the state's responsibility in some ways, because this whole notion that, we didn't know doesn't no longer apply. But what's probably more importantly, and I think, a lot has been said on this panel about kind of the conceptual parameters and limitations of the state responsibility to investigate and prosecute. So I would add probably here one piece of this responsibility, which is to say so. I think one thing that can really change at the early stages of a conflict or a situation where mass atrocities are likely to happen, the change of plight of civilians caught in such situations, is if there is a very strong notion of accountability, not 10 years down the line, not 3 years down the line, but pretty much as the first bullets start falling. And that's linked to the idea that, for me, a big part of the state's responsibility to investigate and prosecute is the idea that states have a moral responsibility to say that they will. The statements that we often hear when, even from, well-meaning NGOs, international organizations, and states, is that both parties should adhere to the principles of international humanitarian law, for example, or respect for human rights. I think a very important notion that should be added there is that, and if they don't, we, the states, have the responsibility to act, and we will. And I don't think we hear this notion very often. And I think, as civil society, we can do more in the advocacy space there. The other, I think, point I wanted to make on that is kind of more the practical challenges, moving, further from, or putting my advocacy hat aside for a second. I think what we are seeing in our work a lot, interacting with the states, both, in our work on ICC prosecutions, but also national prosecutions under universal jurisdiction or not, is really the massive practical challenges that the states, even those who are willing to apply this principle for real, face in trying to do so. So a lot of it, and I think, there can be a lot of discussion about the resources, the capacity, but I think the trend here is good. The civil society, the private actors are really moving more and more into the space of supporting the states in fulfilling this responsibility, not just reminding them and bashing them for not doing this, but really supporting them. And there, I think, we will probably talk a little bit more about universal jurisdiction, but I wanted to expand it a little bit to also include national prosecutions, because our work at the Clooney Foundation at the docket now focuses on both. And there we're looking into both national prosecutions in the states where atrocities were committed. And I think that's a very interesting and a very promising, forgive me for being an incurable optimist, trend out there. If we're looking at what's happening now in DRC, it's one of the most encouraging things that you can see, where the community itself is directly involved in the justice processes. And I think there are many more possibilities out there going forward. And the other one is the national prosecutions in states where the enablers of international crimes are based. And this is a lot what we do on corporate complicity, working, for example, on companies involved in reselling DRC gold, or the famous Lundin case that is now evolving in Sweden, or for example, the work we're doing on dealers of antiquities looted by armed actors in different countries. So all of these cases are open kind of new challenges, but also new possibilities. And what we see is that there is significant appetite from national prosecutors to prosecute these cases, but we also see that, frankly, without significant support, including on the investigative side, from those private actors who can provide them with necessary information and resources, they probably would not go very far, or will take forever and ever and ever, as we can see in Sweden. So I think that's for me is one of the key challenges there, how we, again, speaking from a practitioner from civil society, how we can combine the advocacy with the practical support to the state bodies in these cases. And probably one or probably two related final notes that I would like to add. One is, in all of these cases, universal jurisdiction, national prosecutions, what to this day I don't see enough is the agency and the voices of the survivors. I feel that in so many cases, they're really driven by either state law enforcement agencies or even non-state actors, but they don't really bring to the forefront those whose rights were violated in the first place. And I can probably speak for about 2 hours about all of the challenges of doing this. It's not an easy thing to achieve, but I think without that, we're not actually living fully up to the Nuremberg Principles, as long as the survivors are not fully present in such proceedings. And related to
Anya, just expand on that little bit, on the survivors not being part of the proceedings, because I think that's really important here. What's driving your concern about this part, and how do you define the idea of survivors, victims being part of the proceedings that you mentioned?
Well, I mean, in practical terms, there are different ways of doing this. In many civil law jurisdictions, what we are trying to do is always bring the survivors or representatives of the communities of the survivors as civil party into the process, and that's not very easy. We saw significant reluctance from the prosecutors, especially in cases that are significantly advanced, basically suggesting, if not directly, but implying that it would complicate the case, which is true, it will. But of course, this is not the excuse that we're very comfortable with. In other cases, it's very logistical challenges of bringing the survivors, even as witnesses, let alone as victims in the proceedings, because in many cases they're based very far away, and many of the prosecutors and court systems are not, judicial systems are just not equipped with various ways of remote participation. But I think this is all kind of on a very practical level. But more importantly, at the very start, my question is: do we always ask, we as civil society organizations, but also the prosecutorial bodies, when we go into a case, are we very clear that this is what the survivors want? Do we fully represent their interests? Is the outcome of the case will really bring the justice and redress that they need and want? And that, of course, creates another challenge, which is, what if it doesn't? Does it mean that we should not go ahead with the case if we believe that it will still serve the interest of justice, of bringing the perpetrators to account? But what I think is necessary there is this dialogue and bringing the the survivor communities into this conversation very early on as we consider these cases, so that we can fully address these challenges, one way or another.
But that would include, you're suggesting, even before, let's say an indictment occurs, but even before a case moves forward, you would bring in the survivors, the victims, or their representatives to determine whether or not, in fact, this is the right path that we should follow. Is that part of your suggestion?
I think so. And I know it's not without controversy, which we're struggling with entirely. But I just feel, I suppose, less and less comfortable with us, in the most broad sense of the word, deciding what justice should look like, right? And I, having worked, all over the world with the survivor communities, I have seen that their own desire for justice, we're not talking about very material things, their understanding of what justice is, and their desire to overcome enormous difficulties and the risks to achieve it deserves our consideration, ours as the civil society players and ours as practitioners in the courts and prosecutorial bodies in any country.
No, let me ask too. You mentioned, Anya, when you first talked, you talked about the atrocity happens and the world knows, and it would be difficult to deny those atrocities. It seems that the rise of social media, I mean, we hear a lot of criticism about social media. I suspect we could have a conference just on that, on those issues. But social media has, I think, in the sense of citizen journalism, the ability to put out on YouTube, for instance, videos, pictures of atrocities that are occurring. Even the International Bar Association has an app, Eyewitness to Atrocities. It's focused just on that. Is that the main reason why the driving force behind this awareness that you talk about is simply because we live with technology in a way that we can see these things happening, and the world sees these things happening, not in a month, not in a year, but tomorrow or today?
In short, yes. I think, of course, that has changed the landscape completely. It absolutely has. And of course, it creates its own challenges. I would say, as an investigator, about half of my job now is verifying everything that's coming out of, social media and other channels that the people use to report. But I would say, and again, maybe I'm sounding too kind of optimistic or having too much faith in humanity, but I think it's also that the notion of justice and the notion that if the world knows something will happen has become much more universal and accepted in the communities themselves. I think when people record a crime being committed, a human rights violation being committed, they put it on social media, not just for the purposes of informing the world, but because I think we got to a point where, and I think it is a very positive development, that informing might lead to action, which I don't think was the case before. I think there is much more understanding, and that is due to citizen journalism, but also I think due to the fact that the work of human rights organizations, of organizations that represent the victims of mass atrocities, is now much more common than it used to be 50 years ago. And I think slowly but surely this notion becomes something that that people who are victims of witnesses of these atrocities understand, at least subconsciously, but maybe quite consciously as well.
Okay. Well, let's talk. I want to elaborate a bit on some issues, and in fact, the organizers had asked me to answer the question about what's missing from the legal regime and how can we strengthen the accountability for these core international crimes. Both of you have alluded to that, and I just want to put some points out there to see how you respond to it in our audience as well. And I kind of looked at this, and I think this was reflected in day one of the conference when it was discussed about the important role of the International Criminal Court. We can't deny that because that in the arc of justice seems to be the pinnacle in the sense of ensure, or attempting to ensure that accountability is brought to bear. But there was also a recognition that it's not the only one, that there are other competing and complementary entities, elements to this. I had kind of looked at this in a three-prong way, and I'm adding a fourth one when I listened to Akila. So the first one was the international and domestic war crimes courts together, because I think they're the two sides of the same coin. The second, and Anya mentioned this too, on universal jurisdiction, that's one of the prongs. The third, Anya had referred to it, but not by name, but I suspect it's the same thing, and that's the responsibility to protect, the R2P, but by, as she was saying, kind of raising the awareness of this. State responsibility has a moral responsibility to act, as Anya says, and this is really the responsibility to protect. Then the fourth, I have to say, which I would add, is what Akila says, and that's civil society on that. So if I were to just take the first one about the ICC and the domestic courts and look at that together, knowing that the International Criminal Court exists on this concept of complementarity, that the complementarity it really says that the hub of international justice is on the domestic side, that the ICC is only going to act if, in fact, the domestic actors are unable or unwilling to participate. So, a couple things. When we look at the ICC first, in that, and its overwhelming motivation that it's there to put an end to impunity, there are some struggles there, the realities when we talk about how do we strengthen international justice, and we look at the ICC. And I'd be curious your responses to these points. One, is it really truly an international court? We know that some of the major players, the United States, China, Russia, Israel, are not members of it. We also know that some states, the United States being one, has been quite hostile to it. Can the ICC truly represent the international community? Second, the role of the UN Security Council. The role of the UN Security Council in relation to international justice in general, but the ICC in specific, I think is underwhelming. I think we can say that Security Council has been in many ways unhelpful to the court, and in some ways, I think, really intrusive. third, and this is really important, I think, in the perception that the public might have, is it an effective, efficient way? Is international justice through courts, particularly ICC, efficient? Since the inception of the ICC, there's has been maybe 10 convictions, 4 acquittals. That's important. But I think if you were to add up the money, it's probably over $2 billion. Is that an effective way to secure this issue of accountability? And finally, the issue, and I think this could be seen as a central challenge, is consistency by nation states. International justice, I would say, is not equitable. Powerful states can escape accountability, the powerless cannot. How do we respond to that when we're looking at strengthening accountability, strengthening international justice, and looking at the International Criminal Court as a key component? What needs to be done to ensure that that exists? Akila, you want to try that?
Yeah, no, just some very simple questions there with no real complexities in the answer. I guess I'll pick up on a couple of them. I mean, I think this last one that you're talking about, Mark, is really connected to the first question you asked about, is it truly an international court, right? And what that looks like. So, we struggle with this a lot as an institution that's based in the United States. We often get questions all the time around, well, what are you doing about your own country? Why is, how is the US being held accountable? And I think certainly there's some very serious questions there. I think the first one is, when you talk about whether the ICC can actually be an international court, I think, the recent announcement that certain parts of the Afghanistan investigation were going to be deprioritized is deeply concerning, because that was one avenue in which to show that actually those states that are powerful states could potentially be held accountable at the ICC, even though they haven't subject themselves to the jurisdiction of the court, right? So I think in the context of the United States, it is a really unfortunate kind of decision. I know there's a lot of different considerations that went into why that decision was made. And, the Trump administration's hostility, its executive orders, and kind of really trying to hamper the court were probably at the core of some of that concern. But I think that's one thing that we have to grapple with. And, we really look at a role that we're playing is in thinking about these concepts of the multilateral system as a whole, actually, and about what it means. And are these, larger questions of, are these systems colonial frameworks, right? What does it look like to decolonize international law and justice, international human rights? And I think a piece of the puzzle there is to actually call out the powerful actors that refuse to subject themselves to the same frameworks that they call for application for other states, right? Because I think it's very disturbing that you have this idea that, using the United States as an example, that the United States is a pillar of human rights, is a central part of this system that it refuses to actually subject itself to, right? The fact that the US has withdrawn itself from ICJ general jurisdiction, as well as the jurisdiction from certain treaties, is something that we need to be doing more work to actually call on the United States to rectify. And, even the Biden administration is not really open to these ideas. And this is kind of, I think, something more fundamental that we need to do in the US around thinking about what does leadership mean? What does it mean for the US to lead in the international community? What does it mean for human rights to be central to its foreign policy? So those are certainly questions that we're grappling with. And then I'll quickly just touch on the role of the UN Security Council, because you raised that. And I think, it is certainly, as you said, been underwhelming. If you have an ally on the Security Council who has a veto power, you are essentially protected from being subject to, say, a referral to the ICC. And so we've been involved with initiatives, but there's multiple initiatives around thinking about veto restraint, everything from developing the legal argument around the legal constraints on the use of the veto, especially as it relates to mass atrocities, really important work that Professor Jennifer Tran has been doing, as well as certain initiatives that have actually been set up by states, including on just kind of more amorphous concepts of veto restraint. When are you not supposed to veto a situation? So for example, I think certainly a referral to the ICC for a situation of mass atrocities could fall under that framework. And I think those are some of the reforms that need to very seriously be considered here to actually strengthen what that pipeline looks like, and to make sure that where the Security Council engages in international justice, it's not just for those who don't have powerful allies.
Anya, thoughts?
I'll be brief. I think to the extent that it could be covered, Akila covered that. I think my answer to most of your questions is a no. It's not a truly international court, and it's not truly effective, let alone equitable. But do we still need it? My answer would be yes. And that's, I think, where my position firmly sits, with all the disappointment that came after the initial excitement about the establishment of the International Criminal Court. I was very interested in listening yesterday to the conversation about whether it creates sufficient deterrence, and I hear all the voices that say that it doesn't. I can just testify from hearing on the ground, voices on the ground, of the deterrence that it does create to this day. And so, as long as the buzz about the idea that it could get the perpetrators to justice exists, that helps to prevent some of the atrocities. I'm absolutely convinced. And then, of course, all of the issues that Akila mentioned are something, that need to be both worked on, and that we need to be finding alternatives to. And alternatives could include, hybrid courts, and universal jurisdiction is definitely something that and national prosecution, something that we're focusing much more in our work, for example, than ICC. But I still think that almost as a symbol, it needs to be there. And on the Security Council, I would just say one additional point in addition to what Akila said, is that I think in line with these ideas of how the veto power can be overcome, I think we should not dismiss the power of the General Assembly. That has been diminished very, very dramatically. But I do think that if you start digging into various procedural tricks that you can do with the General Assembly, there is quite a lot that you can do. Again, these initiatives that are ongoing, and I am very hopeful that the UN reform more generally, which we are all craving on so many different levels, will address that as well.
Well, and I think that there's not only is what Akila was saying about the veto power, but we all know that even in issues of cases before the ICC, the Darfur situation was a prime example when the court goes back time and time again to the UN Security Council seeking assistance, seeking support, and getting none. That's troubling, because it suggests that, well, the Security Council made it, in essence, created that case, but didn't have the ability to support when the court needed it. So I think that's the other thing. Anya, your point about the ICC, and I think you're right, and I want to go on record saying I remain a strong supporter of the ICC. However, I think those are issues that are legitimate. I think the public has a right, considering the time, effort, money that's being spent, to ask the questions. And by the way, I think we would all agree the ICC is at a crossroads right now. When you look at the fact that a new prosecutor is in, you look at the issues of a new strategy plan that's come in. I think these are going to be critical years coming up to see if the ICC can pivot a bit back to embracing I think the energy that we all thought it would have, and this I think will be important. Anya, you mentioned something in your point about universal jurisdiction. I want to get into this a little bit, and Akila can respond as well. We talk about that as being an important component, complementary component to the courts, for instance, and to this international justice paradigm in general. In many ways, I think we can say the universal jurisdiction is really the last line of defense if all else fails. You could still hopefully have universal jurisdiction as the principle that in essence says, every country has a responsibility and an obligation to ensure that those that have committed the most heinous crimes are brought to justice. And the most important thing with universal jurisdiction has been in the past the fact they've abandoned these kind of traditional approaches to adjudicative jurisdictions. States are responsible to go after anyone who's committed these crimes. But that's really not the case any longer, is it? That we seem to be having states that still can say, yes, we embrace universal jurisdiction, and even Amnesty International and other groups suggest that the number of states who adopted concepts of universal jurisdictions increase, but it's conditional. That have adopted conditions, so there's required nexus, for instance, between where the victim is and where the perpetrator is in regards to the state. So my point is, and Anya, I want to ask you: are we truly seeing a growth of really aggressive use of universal jurisdiction, or are we seeing it in name only, that because of the conditions that are attached to universal jurisdiction, we really don't have that powerful instrument?
Thanks, Mark. We definitely are seeing it increase. That's for sure. I am constantly reminded of this. For me, it was shocking to find out that actually almost 170 countries in the world have provisions that somehow allow for what we would normally call universal jurisdiction. They're not always called this way, but essentially it is. The data is there. Of course, out of those almost 170 countries, only a handful are using the principle. But again, compared to what it used to be 10 years ago, we definitely see an increase. At the same time, there is a movement backwards in certain countries where there are new limitations, which, as you say, do not really allow this principle to be fully used. But I would say it's I am very hopeful generally I just feel like I'm sounding way too hopeful on this panel, but maybe it's the moment in time to be, that, with the right support from academics, from practitioners, from civil society, we can get somewhere. You say it's the last line of defense, which is of course true. I would say it's also might become the first line of prevention, because again, going back to where I started, this notion that there is nowhere to run, that if you committed the kind of crimes that qualifies international crimes, essentially war crimes, crimes against humanity, genocide, mass atrocities, you would not be able to just cross borders and be untouchable, which used to be the case. And I think that is a very important notion that in some ways we need to communicate. There was a lot said on this panel in previous days about the importance of communicating this. And I think what could really help to strengthen the universal jurisdiction as a principle and as a practical measure is really constant and clear public communication about what it is and what it means, which is very, very important both to the survivors and to the perpetrators. I think this message needs to be out there. And second of all, I think it's really just the practicalities of it. To make it real, to make it functional, you need resources, training, conceptual understanding that is often missing in many of these countries that have the provisions, but don't frankly have the prosecutors who've ever done any of such cases. And doing, your first case on UJ, I think is very, very difficult. And this is where they need support from organizations like yours, like ours, and of course from those who have done it before. So in short, I do think it's promising. It needs to be supported. It's definitely increasing. But the potential there is so much more than the reality that we currently have.
Akila, any thoughts?
The only thing I'd add is in thinking about, the broad range of places where universal jurisdiction could be happening, right? As Anya's talking about, you have 170 states. I think there's an opportunity here to think about how that can help to shift this paradigm of only certain states are held accountable, right? Because if there's a possibility of, thinking about states in the global South, for example, is there an opportunity here if we're able to, think about how to support the resourcing and the development of, places where such cases could take place, to hold actors from powerful countries to account, countries that are often immune from the larger constructs of, as we talked about, what protects them within the multilateral system. And I think that's also something for us to think about and explore as to how you can shift some of these larger paradigms of who can be held accountable.
And who can be the one holding accountable? Sorry, I think it's a very, very important point that actually can increase the equity that we were just talking about by enabling the states that have not been active participants in the international justice system to be there. And I think that is really a very, very important notion.
I think both of those points are absolutely spot on. But I think both of those points suggest that you'd have to require or request, I should say, a much more aggressive form of universal jurisdiction for states to ensure that you can investigate, you can prosecute atrocity crimes regardless of where they are committed, and get away from this conditionality of nexus, because that so limits the strength of the universal jurisdiction principle. If you're just layering on conditions after conditions, you do it enough, and you really don't have much except in name. I'm getting a question in, and if the audience has questions, bring them in. But I'm going to take this one. This is a universal jurisdiction, but this comes from Charles Jallow, who anybody in the international field knows is a giant in the field. So let us three not be too intimidated by this question from Charles, because he's one of the best. So the question comes: universal jurisdiction and its critical role in accountability has come up a few times. We've done that. But as you know, it is also a sensitive principle for some states, especially some from the global south. Keely just mentioned this. Do you think that there is a role for the International Law Commission in clarifying vague, problematic legal aspects of universal criminal jurisdiction as it proposed in its 2018 report to the General Assembly? Anya, you want to take that?
Yes, Mark. And, I think in some ways you just answered that. And the answer is yes. This is exactly where the issue of conditionality could be addressed. I think the International Law Commission is very well placed to do that. And it's equally well placed to ensure that, to the extent possible, given the differences in legal system across states, the universal jurisdiction principle is truly universal, and that the same principles are applied equally in different jurisdictions, to the extent possible. But I would also just, again, beating on my favorite drum of communication, I would say that, yes, it is very important, but it is equally important to find the way for the conclusions and recommendations of the International Law Commission to be translated into public messaging. And I think, of course, a lot of it stays within professional community and is only relevant to those working with this day to day. But if we really want, again, the notion of justice to be more universal, we have to be talking about this at a much broader public level, be it, the challenges with ICC or the challenges with universal jurisdiction. We need to find a way to explaining what it is in simple terms. And I think this is not the role for the International Law Commission, but this is the role for, I think, many of us who kind of connect the two worlds, I suppose, the worlds of, Charles and the International Law Commission more broadly, and the world of the public, for whom this matters. And I believe it is.
Keela?
I think Anya really covered anything that was needed to be said there.
Let me then move back to something, because it was my third in this tripod, although the tripod disappeared when I listened to Akila talk about civil society, but and added that, so it's such an important component of that. But let me get back, Anya, your point about kind of that moral responsibility. I was really taken by that, and I indicated that I thought, well, that's probably at the heart of the Responsibly Protect, the R2P mission of global commitment to international justice and to ensure that these atrocity crimes have that those perpetrators will be brought to justice, and to try to engage states at an early stage to reinforce what you said, Anya, about the responsibility. They have a responsibility to ensure that these things don't happen. I have to say, I've always been a bit uneasy with the principle because I think we saw it used for political purposes in Libya. So I kind of lost enthusiasm a bit for it when that happened. However, it seems to be coming back a bit. We had the Human Rights Council last year adopt a resolution in full support of R2P, but most importantly, this year in May, the UN General Assembly adopted a resolution in the same way, but it was adopted overwhelmingly by states, and most importantly, I thought suggested or deciding that the R2P would be on the annual agenda for the Assembly, and a formal report would be given. Is that it? Am I right to be now optimistic about R2P? Does that play into this configuration that we've talked about over the last 2 days about strengthening the idea of international justice? How important is the R2P principle or is R2P, and are you optimistic that it's going to gain greater strength? Anya, do you want to try that first?
Sure, although it's not an easy one. I think in some ways it's my feelings about that are very similar to my feelings about the ICC. There was so much excitement when the principle first came into play. It was, I think, the same notion that ICC will end the notion that justice can be avoided as long as there is no state to prosecute. It's, moving the notion of justice for mass atrocities or accountability for mass atrocities to truly international space, and R2P in the same way, bringing this idea of never again, turning it into a principle that can have practical application. And then, of course, as you already mentioned, both its political misuse, but also the speculation about the political misuse, which I think made even more harm to the principle itself, left it in limbo. But I do think that the developments that you just mentioned mean that it is probably back, and combined with some of the figures that you just quoted about the number of civilians that have been killed in conflict over the last couple of years, and the fact that we're not seeing a decrease in the number of conflicts, the way they're being fought, and the number of civilians that are suffering through them, but also, quite frankly, the new potential international crimes that are now being talked about, such as ecocide, for example, right? So it doesn't seem like the principle that there is room for the principle to go away. Again, for me, the question is, what would it mean in practical terms? Given what we said about the UN Security Council, given what we said about the judicial ways of applying this principle or turning it into a reality, with all of the limitations that we have, what would it mean in practical terms? And frankly, who has the moral compass anymore? I think this principle always relied on the idea that this moral responsibility lies with the states that have the moral foundation to uphold it. And I think what we've seen over the last few years is that it's really hard to, point a finger to the state that would fully qualify. So it needs to be really a coalition of like-minded states that have that have the moral compass and the, I guess, sufficient support of the international community, a sufficient trust of the international community more broadly to apply it.
But before I ask Tequila on the same question, let me ask you then, Anya, when you say about states having a moral compass, one of the states that clearly led in this field after World War II was the United States. We know the story recently over the last 5 years, which has been a fairly dramatic shift, but even before that, not supporting the ICC in any way. Do you think now? Do you see there's any way of the United States coming back and playing this role, having a moral compass, but leading it, because it certainly did so in early days after World War II, or is this? Has this passed us by that we really shouldn't be looking for the United States any longer to play that role?
Well, I wouldn't say it's impossible for the United States to regain its moral standing. I think it's totally possible. Whether it should be the one holding the moral compass, I'm not entirely convinced. I think it played an important role in this process, and I think it should be acknowledged. But I think, given generally, like even forgetting about the developments of the last few years, generally, I'm not sure that this speaking about the equity and the justice processes and human rights issues more broadly, I don't think it should be the United States or the broadly defined West to start with, because I think the world has shifted dramatically, and we should support this shift from the permanent members of the Security Council holding the keys to everything: peace, security, and justice. I think that's the whole idea that, yes, the council is there, but there are other forums in which, for example, the R2P principle can be upheld, such as, for example, the General Assembly. Again, not that, I have any particular illusions there, or the Human Rights Council, but the forums that are much more representative of the common conscience of humanity than just the United States or Great Britain or Russia or China.
Akila?
Sure. So I think to add to this, I'll say it's not just a moral responsibility, right? R2P is grounded in legal obligations. So you look at, obligations to prevent genocide from the Genocide Convention, the potential to have an obligation to prevent crimes against humanity if that convention is ever, kind of articulated. There's a core here of what is required, and it doesn't just rest on a moral compass or, morality. And I think that's important for us to be talking about. And I think it's important to talk about in the context of R2P, because there's a real need to recast R2P, right? It's so synonymous with humanitarian intervention, but R2P can encompass such a much broader range of, of what actions could be. So one action I think about all the time as potentially an act of R2P, but also as a way of complying with the legal obligation to prevent genocide, is the Gambia of all countries deciding to file a case against Myanmar at the ICJ. It is it is something that is rooted in justice, but it's also something that actually goes towards complying with these responsibilities. They're taking an action through judicial means, through the peaceful settlement of disputes, which is a part of the UN Charter, which is a part of these mandates, which I think we can think about as an act of R2P. So I think we might, as we think and talk about R2P, we need to really have more imagination as to what comes under the umbrella. We need to develop what are the types of actions that can be taken that aren't humanitarian intervention, that are not ones that require, I guess, either the pre or post approval of the Security Council, depending on what you're looking at. And I think that, to me, is incredibly important in this justice conversation about how do we think about justice as a measure, an explicit measure of prevention, and an explicit measure of what we do to comply with these notions that we're talking about.
But are you optimistic, Akila, that you can, with an R2P, that you can have this issue of enforcement? How do you enforce that? I mean, at least Anya's point about, I think, moral responsibility, if it could be adopted, is probably an easier result, because people would be there already saying we have a moral responsibility. if you're saying RTP is still within the legal framework, the enforcement issue always comes up, doesn't it, for the legal port? Can you enforce these standards? And some would argue that we have had a fairly miserable period of time to see enforcement of this. So you remain optimistic that we can still enforce the obligations that are set down by R2P in the world that we live in right now?
I think we need to think about what that looks like and how we hold those accountable, right? There was when we were looking at things related to the ICJ and the Genocide Convention, there was a really interesting filing in the Bosnia case that was withdrawn very quickly, but they actually filed an intention. Bosnia actually filed a thing that said that they intended to file cases against the UK and some other states for their role in the arms embargo, as an act that actually continued to perpetuate genocide. And I think it's really interesting as we think about what do actions like that look like, or how can we hold these other actors responsible for their failure to do something in face of these. And I think we need to think more expansively here. I think there is potential. I think we often think far too narrowly about who needs to be held accountable for what. And I'm hopeful that, especially with new actors getting involved in this, in this space, the space for new developments, that perhaps we can move in these directions. What would it mean to hold, a country like Russia accountable for what's going on in Syria? And I think those are questions that we need to very much grapple with, because that goes to the core of how you resolve some of these things. And it also goes to the core of, I think, making the multilateral system more relevant again, which is a part of, I think, what we're grappling with all of the questions that we're asking today.
Well, let me ask then a follow-up. It actually comes from the audience, which I'm eager to get to. And I know we're probably coming to the end of our time here, but I think this is relevant as we're talking about. The question was, how can we together help establish swifter justice? Now, the pre-question on that is, should that matter when we're just struggling with justice, of increasing justice generally? But is this an issue that we need to be concerned about? That maybe there's a perception that justice is too slow. Certainly, we've heard that, and we need to work together on swifter justice. Is that an issue for either of you, or is that not your priority right now, Anya?
Just very briefly, I think we should be careful with the swifter justice, but because, swifter does not necessarily mean fairer and equal and representative. But yes, of course, justice right now is slow. There are many things that can be said about this. I would say that my work currently is mainly about addressing this specific aspect. So to the extent that private actors can be involved and can feel the resources and capacity gap of those who are supposed to deliver this justice process, we can make it swifter. When we come to the prosecutors with basically a dossier that has 2/3 of the investigation done and leaves all the necessary that cannot be achieved by the private actors to them, I believe it will expedite the processes without undermining their fairness. And I think there is definitely a movement there for allowing the justice process to be more inclusive in terms of evidentiary standards, in terms of the participants. And I do think it has a potential of delivering justice in less number of years than it's currently being delivered.
Akila, last word.
I think it also depends on what you define justice as. I think you can have different levels of justice that could be faster depending on what is it. Is it putting someone in jail? That may take a space of time. Is it, a prosecution at the ICC? That's certainly going to take more time. But, if we think about this broader construction of what can be included in the framework of justice, and I think this is where it's really important. Anya talked about this, the need to involve survivors in the design of justice, right? Is justice about truth telling? Is justice about certain forms of reparations? As you have an entire framework. Is it guarantees of non-repetition? Are those things that can be pursued in parallel to criminal accountability processes? And can some of those be rendered faster? Potentially. I think we need to think about and broaden this concept and bring in those who are affected to let us know what justice looks like, because there may be simpler ways that we can help at least move towards a justice paradigm that we don't think about, that's not just about accountability in like this big justice way.
Great. All right. Well, this has been fascinating, and I want to thank those who have participated through this webinar. Jolana, I'm going to turn it over to you, but just to end by saying, I think we can all agree that this remarkable shift in international law has occurred, and the real challenge for us is to continue to strengthen it, maintain it, and give it momentum. So thank you all very much for participating. Jolana, I'm handing it back to you and to Klaus.
Thank you, Mark, and I'll give the floor to Klaus first to thank everyone from his side.
Well, thank you, Jolana, and my particular thanks and my deep gratefulness to this and to all panelists that we heard in the last 2 days. You have been remarkably prepared, remarkably engaged, and you have added so much wealth to a very rich discussion that if I had to summarize it, I would almost need 2 days for that. So it's almost impossible. So thank you very, very much. It really shows that our idea to bring together all these insights from the various experts into one conference leads to a very condensed and rich and fascinating discussion, which is a great stock-taking exercise after 70 years of the Nuremberg Principles. We had planned this conference last year where the actual 70 years anniversary happened, and we were right not to ditch the topic just because the year had gone and we couldn't come together because of COVID-19. It's on the contrary. This conference has shown how important it was to have this discussion, this exchange of views. And again, my great and deep gratefulness to all of you. Anja, you've stepped in on an extremely, I would say, inappropriately short notice, readily filling in for another speaker who had to withdraw on last minute. Thank you so much. It was really a pleasure to have you here, and rest assured, we will invite you again. That applies to all of you, by the way. Now, what to say after these 2 days of a conference? And the easiest thing would, of course, be trying to answer the question, are we living up to the Nuremberg Principles? Well, principles have one big advantage. They tell us what to do, but they don't tell us how we should do that. And we have seen so many ways of how the principles can be implemented that I would rather say, well, I think to a large degree we do. And we see this by the various activities and elements that start, of course, with the establishment of the International Criminal Court. It's the only court where the Nuremberg Principles are actually codified. And this not for an ad hoc or for a specific situation, but in permanent. And if people say, well, this is a treaty-based court or only a treaty-based court, well, the entire United Nations is treaty-based. Anything between states is treaty-based. There is no other tool because there is no world legislature. So from that point of view, it is, I think, a very viable tool, and it is also an international tool. But what the discussion has also shown here, that there is so much to be done to avoid what the Nuremberg Principles actually want to avoid, and that is impunity for the most heinous crimes. And the discussion has shown light and shadow. Shadow, of course, where we see obvious gaps, and the veto powers in the Security Council have been identified in more than one panel as a clear obstacle to achieve impunity as a general standard, because some countries, some powers have veto powers and can escape the jurisdiction, whether it's a universal one or a specific one, doesn't matter. They simply withdraw and pull the veto card, and then the discussion in the Security Council ends. So that is something where work has to be done, and the work has started. And that's, I think, the positive note. That is not something that people say, oh, okay, that's something we can't change. Yeah, we can change that, and there are numerous initiatives, including initiatives supported by veto powers themselves, which for me is the most positive signal. We see states actually availing themselves of all opportunities. The Gambia has been mentioned in that regard, and other states do whatever they can. We see the United Nations with the General Assembly and other tools establishing the mechanisms. Well, it is, from my point of view, a piece in the puzzle to avoid impunity. The evidence that is now collected might be able to help us in a couple of years to actually pursue justice and to prosecute and adjudicate co-international crimes. How often in the history of the world has it happened that the evidence was burned and the witnesses were killed before the first investigator actually felt mandated to do so? And I commend all private civil society, non-governmental organizations that fill the gap and simply start collecting the evidence. Certainly, advanced technology helps us there. This is actually one of the reasons of the importance of these new tools, why the Nuremberg Academy is undertaking a larger research project on the future of digital and electronic evidence, because we know this has changed the world significantly. What remains to do is a lot, and that is not only because we still have these gaps today, and we still have the situation that not all crimes are investigated and prosecuted. And it takes indeed what has been said by Anja, I think, to be an incurable or notorious optimist to not lose the power. On the other hand, if you look at public international law, 70 years is hardly a time span in which you establish customary law. If you ask a doctrinal scholar on how long it takes in international public law to establish customary law, the answer will be probably a couple of centuries before you can do so. It's a very young material with which we are talking here, and for that, in this remarkably short period of time, I think this progress has been significant and gives rise to continue the work. I could go on for very long, but let me just conclude with again thanking all panelists for bringing so many important topics to the discussion. This wonderful comparison of national, regional, and international attempts to actually implement the Nuremberg Principles and make them and get them into a codification, whether treaty-based or not, is, from my point of view, not so relevant. The Nuremberg Academy will continue to support each and every one, states, organizations, in their work and in their activities to implement these principles. We do this through capacity building. We do this through research on contemporary topics, and we do it through conferences like the one we just seen the 2 days, because I truly believe that this exchange of views and these discussions are truly enriching and advancing us all in the field. So this Nuremberg Forum was the first one that was held in a digital format. And I must say I was a bit worried at the beginning. On the other hand, we never in the history of the Academy had so many people watching the discussions. So digital formats also have their advantages, although I must confess I deeply, deeply miss the personal exchange with all of you. And I can only encourage and invite all of you to come next year to the Nuremberg Forum of the year 2022. And I touch wood 3 times to hope that we then have overcome the pandemic situation to a degree that allows us to get back in person. Please mark the date already now. I know it's very early, but 14 and 15 October 2022, we will reconvene in the Nuremberg Forum 2022 under the topic of A Court in Practice, 20 years of ICC between 2002 and 2022. I'm sure there's also lots of discussion and I'm looking forward to these discussions. Stay tuned, stay in touch with the Nuremberg Academy. Not only this conference, also other conferences are on our YouTube channel. So if you have missed the panel, if you weren't able to follow all the discussions, nothing wrong with that. You will be able to recap and to rewind the one or the other discussion, and that remains available for everyone. Big thank you also to the team. First and foremost to Jolana and her colleagues here in the Academy, but equally also to our technicians who have supported us in this event. You have taken a great risk in organizing the first and hopefully only virtual Nuremberg Forum in the history of the Academy, and I can only say, well done. And with this big thank you, Jolana, I hand back to you. To all of you, I hope I see you again very, very soon. Thank you all so much.
Thank you, Klaus, and thank you, everybody. There is not much I can follow up in terms of substance because Klaus has covered the variety of the topics being discussed, dissected, and the objectives and the challenges raised. And the only part that I can add to that is that we are aiming to do a brief conference report following this event and publish it on our website as per usual past practice. What I think I can still do today is to briefly reflect on the objectives of the Nuremberg Forum. So I think we have achieved all of them from a very quick look at the notes and various discussions, but we have discussed and dissected the legal framework envisaged in 1950 and then subsequently developed in the common fight against impunity. We have looked at this issue from substantial, structural, and doctrinal perspective and underscored and try to really summarize various challenges related to them. We also situated the Nuremberg Principles within this framework, reflecting on establishment of the Nuremberg Principles, the continued relevance and importance, and analyze them also through case studies. And last but not least, we identify strengths and weaknesses of the current fight against impunity system while reflecting on whether the Nuremberg Principles or Nuremberg legacies in that respect are respected 70 years after their formulation. And we had done all of that thanks to you. I think the three key points that we have taken away, and again on a very short analysis time with the wealth of expertise shared, which will require a bit more substantive reflection from our side, but are definitely highlighting the importance of the Nuremberg Principles, the relevance of them, which we have seen throughout the two-day discussion, and the need to continue the ongoing and very continued dialogue on the fight against impunity and the wider accountability efforts. And we are very happy that this conference itself could contribute to this dialogue to some extent. As Klaus mentioned, this was our first virtual conference, so we will be sharing, and also our feedback form is available on the platform. We do encourage each one of you to reflect your impressions on the forum, on the platform, how we can make it more engaging and interactive. It is an exceptional situation this year, but I think, and hope Klaus allows me to say this, that the hybrid element is going to be with us to some extent also in the future, and we would welcome feedback on in terms of how to really connect much better and how to really bring the subject better and the content discussion much more forward. And that just leads me to the final thank yous. So first of all, thank you to all panelists. We had done extensive test runs to make this platform working with the technicians on the substance and topics. We have had much more limited time than we would have if we are in courtroom 600 and with the various breaks and coffee breaks and dinner discussions. So we are grateful for the flexibility for really working together to try to highlight as many challenges and way forward that we can. Then the second part goes to the team who have continuously worked on really mapping out various venues, various challenges, and trying to boil down the questions, and also kind of the practice behind the technical setup that we have managed to do. And then the last one is to our technicians who have spent hours and hours trying to get the Nuremberg platform running with as many interactive tools that I hope you used over the past 2 days and get to connect also with your fellow colleagues and experts in the field. And I think that, yes, leads to our appeal to continue supporting and following our work and engaging on the various topics that we have before us. And I'll head back to Klaus for the final closing.
Thank you very much, and not much to add, truly. Maybe just one thought. When the Nuremberg Principles were established, the world was a different one. And if we look today into the future, it is not going to be easy. On the contrary, it's going to be more challenging. We have the climate crisis coming. We have a deepening distance in economic situations of countries. All this is giving rise the thought that most likely conflicts, even armed conflicts, may rather end but decrease. The more important it is that we have a robust framework in place in order to do what we can, whether sufficient or not, what we can to bring perpetrators for core international crimes to justice. Because there I couldn't agree more with Anja. It is ultimately the victims and the survivors of these crimes why we do that, to give them back a little bit of the dignity and the recognition they deserve. And this is what motivates us all. So thank you all very much. I hope you will have a good and relaxing weekend ahead of you before, most likely on Monday, 9 o'clock local time. Of course, we all start to go back into our fight against impunity and for human rights across this world. I hope you all stay healthy, and I hope I see you all again. Bye-bye.